Welcome all to the critical analysis of Dicey's rule of law under rule of law. This is Dr. K. Sangeeta for administrative law. Dicey's expression of rule of law is based on wholly misconception. He has not foreseen the evolution of the system due to which his theses not support administrative law. This is one ideology and school of thought that was criticizing Dicey's rule of law, because Dicey was explaining the administrative setup in United Kingdom. Inherent ambiguity. Decision of the parliament always based on majority's decision. In this sense, majority holds arbitrary powers. If parliament enacted bad law and passes a bad law, then it is a rule of law. Consider it a supremacy of law. Here next is a discretionary power. He did not anticipate the increased need for discretionary power in modern state, the need for the legal control of such powers. Dicey's opposition to discretionary power has been characterized as being driven by his opposition to government intervention. Discretion is now seen as necessary for decision making required in an increasingly complex society. However, discretion should still be constrained by value of rule of law, such as fairness, impartiality, and equality. The first principle also cancels out the fact that a matter of essential competence, many present-day statutes allow police the power to detain people for short period of time due only for the reasonable suspicion. Here discretionary power or arbitrary power, where new devices have been instituted to give relief to individual against maladministration and subtle abuse of discretionary power. Topics like Ombudsman, Central Vigilance Commission, Supreme Court guidelines and judicial review help in finding out or managing maladministrations or abuse of discretionary power. According to Jeffrey Joel, in modern state, discretion is necessary to carry out a variety of welfare and regulatory tasks. Nevertheless, the rule of law contains a number of important values including legality, certainty, accountability, efficiency, due process, and access to justice. These are not only formal values but also substantiative. The rule of law is not a theory of law but a principle of institutional morality inherent in any constitutional democracy. Equality before law. If you see this picture would be explaining a lot about equality of people or equality of people before law. Here, Supreme Court was talking about equality has to be seen among equals. This is the picture that depicts the conservative and the liberative understanding of equality and equity. So here equality, you could see the differences that is underlying in these three persons who are watching the same show. But when you talk about equity, there is a sharing that is being given to, so that the persons enjoy seeing it in a proper way. So this concept of equity should be existing in society is the thinker's view. But if you see the later picture, it talks about equality, equity, and what is in reality. So this disparity that is existing even after many steps taken by the government. Example, schemes for uplifting people belonging to different class. Because when you talk about liberty of a person, here the freedom and the rights are taken in only two aspects in the eye of law, which is status and economic background. So here, if you see in reality, the disparity is far, and in liberation thought it should have been common and easily seen. So this difference and this picture depicts all this in a very clear way. Members of police force may be able to exercise considerably more lawful power over members of society than the average citizens lawfully could. But this could be said for a police state, but calling us a welfare state, it is not true that the public officials and private citizens have same rights, and thus whether they are equal is the question that arises. Example, a tax investigator, for example, has power which the taxpayer does not possess. The principle of equality before the law has raised significant problem for establishing rule of law. It would be unjust if the law failed to account for social difference and disadvantage and simply presumed that everyone was equal and should be treated equally is a false. Legal certainty. Dicey's explanation of legal certainty provides insufficient protection for individual right and freedom because it is more concerned with due process than the content of law. Dicey's rule of law provides no criteria for deciding whether a statute excessively restricts civil liberties. Theoretically, Dicey's definition of rule of law would allow an act of parliament to authorize even torture so long as it is sufficiently precise within the terms that is being explained. The requirement of rule of law can still be meted out if these decisions are taken within a framework open, stable, clear and with general principles, as said by Joseph Rawls. As it agrees that the government need discretionary power, but it thinks that law limits how they are exercised and therefore no discretion is absolute and it is always limited. This curbs out Dicey's doubt regarding the seed of despotism being planted. Lord Bingham in 2010 argues that there are 8 principles which should be used to define the meaning of rule of law. The law must be accessible, intelligible, clear, predictable. The question of legal right and liability should ordinarily be resolved by application of law and not the exercise of discretion. The laws of the land should apply equally to all and save to the extent that objective and differences justify differentiation. The law must afford adequate protection of human rights. Means must be provided for resolving without excessive cost or delay civil disputes which the parties cannot resolve themselves. Ministers and public officers must exercise the power conferred upon them reasonably and in good faith for the purpose for which the powers were conferred upon them and without exceeding their limits of such powers. The adjudicative procedures provided by the state should be fair. The state must comply with all its obligations under international law. Thank you.